As a young child, Virgil Darnell Hawkins had one dream: to become a lawyer. In April 1949, with the support and encouragement of the NAACP, Virgil Hawkins applied for admission to the University of Florida Law School. He was found to be qualified in every way, but his admission was denied solely because of his race. In defiance of the clear precedent based on Sweat v. Painter, previously decided by the United States Supreme Court, the Supreme Court of Florida approved the opening of a separate law school at an established black state college, Florida A&M, for the sole purpose of excluding Virgil Hawkins' admission to the University of Florida.
Say that that law school satisfied the legal responsibility of offering education to Virgil Hawkins, and for that reason, he had no reason to complain.
Virgil Hawkins refused to attend Florida A&M.
It was my understanding that Florida A&M, the law school there, was created for the express purpose of having a law school for blacks so that they would not have to be admitted to the white law schools in Florida. This was not unusual throughout the country at that time. They created law schools. Some of the states were paying tuition to have blacks go out of the state, so to go to law school someplace else. Many of the southern states were using these diversionary tactics.
I knew the struggle I went through, having to leave my home state to go to another state. I encouraged him. I said, Virgil, I think what you're doing is great, it's noble. I said, I'm sorry that I didn't do it. I said, I'm sorry that I took the handout that they gave me and went to the University of Michigan. I said, you're doing the right thing, keep on going.
There were whites here in Daytona who constantly requested that the president would fire him because he was a troublemaker and he was trying to get into the University of Florida and whatnot.
But I can faintly remember them talking about the seriousness of it, you know, and the cross that was burnt. It was one burnt in front of my grandmother's house.
Over the next few years, Hawkins' petition to be admitted to the University of Florida Law School was repeatedly rejected by the Florida Supreme Court.
His case was we had appealed it to the United States Supreme Court on the legal issue involved, not a factual issue, and it was set down for a hearing. Brown versus Board of Education was heard earlier in May, and Virgil Hawkins was set down somewhere around May 22nd or May 24th, and the decision was rendered right after the Brown case.
In the landmark case of Brown versus the Board of Education, the United States Supreme Court held that segregation in public school facilities based upon race, even if the facilities are equal, is unconstitutional. Now that the United States Supreme Court made it clear that race could not be the sole basis for discrimination in its admissions policy to a state university, the Florida Supreme Court, in an effort to exclude Virgil Hawkins, determined that admitting him to the all-white University of Florida could cause grave and serious problems affecting the welfare of the students. The Murphy Commission was set up by the court to investigate that concern.
It certainly just looked like to me that this was a delaying tactics to forestall and to postpone the admission of Virgil Hawkins to a all-white institution.
Florida Supreme Court Justice Terrell, in his concurring opinion, cited animal behavior and the need of different species to segregate. He further wrote, When God created man, he created each race to his own continent according to color. Europe to the white man, Africa to the black man, and the America to the red man. But we are now advised that God's plan was in error and must be reversed.
I find it incredible that this court would have said what it said, even in those times. Some people I've heard would tend to justify it by saying it was a different time. But the law was not so different than it is today. And there's no way to escape the fact there was an outright defiance of the United States Supreme Court that said that you shall admit Virgil Hawkins. This court, one of the few courts that I've ever heard of in this nation, to say, we're not going to do it. We're going to find as many ways to keep him out as you can find to try to put him in.
The Hawkins case again was brought before the United States Supreme Court. This time, the court was very direct in stating, as this case involved the admission of a Negro to a graduate professional school, there is no reason for delay. He is entitled to prompt admission.
They didn't retreat from the original decision, and they said that he was entitled to admission. And we thought and felt that admission right away, and as a result of that, Virgil Hawkins went over to the University of Florida to register. And at that particular time, he was denied admission.
In May 1956, the Murphy Commission reported to the Florida Supreme Court that desegregation at that time would cause serious public discord at state universities. In March 1957, the Florida Supreme Court for a fifth time turned down Virgil Hawkins' petition, stating that the burden was now on Hawkins to prove his admission to law school wouldn't cause great public mischief.
The Florida Supreme Court was really overruling the United States Supreme Court.
Federal Judge Dozier Devane, who was assigned to this case, offered Hawkins an ultimatum.
At the very last moment, when the trial judge was forced to implement the order, he went to Hawkins' attorneys and said, you've got two options. If Hawkins remains and you want to admit him, I will allow the state of Florida to litigate his qualifications. And that would mean that the case would likely go on for 3 or 4 more years, up and down the courts, litigating whether he was qualified, whether the 1949 order was in fact accurate, saying that he was qualified, and in the process, many other students would not have a chance for admission. On the other hand, the judge said, if Hawkins withdraws, I will enter a blanket order right now saying that qualified applicants can be admitted.
Virgil Hawkins selflessly agreed to withdraw his original application to the University of Florida after his 9-year court battle so that other blacks could be immediately admitted to the University of Florida.
Virgil made it possible for me to go to law school at the University of Florida, and made it possible for me to open the door for the rest of the blacks that came after me. And so I see him as kind of the father of the black legal profession in the state of Florida. He made it all possible.
In 1964, Hawkins graduated from the New England School of Law. He had plans to come back to Florida and be an attorney representing the clients from his hometown. Unfortunately, his school had not received ABA accreditation prior to his graduation, and Florida would not allow him to sit for the bar exam on the grounds that the school he went to was not an accredited school.
After pending for 2 years, the Florida Supreme Court granted Jim Shook's petition for waiver of the bar examination requirement for Virgil Hawkins. On February 8, 1977, Virgil Hawkins was sworn in as a member in good standing of the Florida Bar. At the time of his admission as a lawyer, Hawkins said, "This is the proudest day of my life. I want to start a legal services program for people barely making a living, who don't qualify for legal aid but still can't afford to hire a lawyer." The year started out in a positive way for Virgil Hawkins. He received the National Bar Association's Gertrude Rush Award, their highest honor, for opening the legal profession for blacks in Florida. In addition, then State Senator Carrie Meek introduced a bill in the Florida legislature to name the law library at Florida State University after Virgil Hawkins.
I thought it was an excellent idea, and it would be a fitting memorial for Virgil. So I filed a bill to name that building after Virgil Hawkins. I cannot tell you the furor that caused in the Florida legislature.
Immediately after Senator Meek's bill to honor Mr. Hawkins was introduced in the legislature, a pending grievance against him was made public, violating the rules of confidentiality. The grievance alleged that Mr. Hawkins had acted incompetently as a lawyer for what amounted to a minor error in a criminal proceeding. In November 1983, Hawkins appeared in his own defense before the Florida Supreme Court to contest the Florida Bar's recommendation that he be temporarily suspended as a lawyer.
The 28th of this month, I'll be 77 years old. And all of you know, all of us know, that at the age 77, the sand in the hourglass of time is swiftly running out. I would hate very much to be suspended on a little thing and I leave here not a member of the bar. When I get to heaven, I want to be a member of the Florida Bar.
The attempts to remove Hawkins from the legal profession did not end with the unsuccessful effort in '83.
On April 19, 1985, at the age of 78, with some grievances pending against him, Virgil Hawkins voluntarily surrendered his license to practice law. Virgil Hawkins died February 22nd, 1988. Within 2 months after Hawkins' death, Harley Herman petitioned the Florida Supreme Court to posthumously reinstate Virgil Hawkins as a lawyer in good standing. On October 20, 1988, almost 40 years after Virgil Hawkins applied to law school, the Florida Supreme Court posthumously reinstated him as a member of the Florida Bar. The court acknowledged the injustices visited upon him in the past, as well as the difficulties he had to face as an attorney. Harley Herman next initiated a campaign to name the Civil Legal Clinic at the University of Florida in honor of the man whom they had previously denied admission, Virgil Hawkins. Governor Bob Martinez signed into law the bill passed by the Florida legislature, which renamed the University of Florida Legal Clinic the Virgil Darnell Hawkins Civil Legal Clinic.
From an historical standpoint, I think young blacks ought to know that it just didn't happen, that there were people, fighters like Virgil, that made it happen.
If you don't know where you come from, you don't know where you're going. So that it's a fool that forgets his past in terms of trying to chart where he's going in the present. So that I think that any person who wants to be well-based and get a good foundation in life, that they ought to know about the Hawkins story.
Virgil Hawkins never sought personal glory. Like other truly great people, he rose from the trenches in battles he never planned to fight, and sacrificed himself so that others could enjoy the inalienable rights to life, liberty, and the pursuit of happiness.